And I guess unlawful trespass and unauthorized operation, all kinds of other good stuff. We are live. This is Senate Judiciary. This is Wednesday, March 20th, the first full day of spring, and it's snow in the ground out in Montpelier. Welcome everybody to spring.
The weather in Vermont does not respect the calendar.
No, it doesn't. You know, we had warmer weather last night. Like plant areas are greening up in Bennington. They could fool. But anyway, so Michelle, why don't you lead off with kind of a walkthrough of the bill and what it does, doesn't do.
Sure. So good morning. For the record, Michelle Child's Office of Legislative Counsel, and we're taking up H563 as passed by the House. And Senator Sears is correct. It's relating to a variety of motor vehicle offenses. So the first section is amending the statute for grand larceny. I think y'all have done quite a bit on, or at least you're probably delving into the theft bill now and the issue around like the petty larceny and grand larceny and the $900 threshold. So what this is doing is adding a new subsection B on attempt to steal a motor vehicle. You do have a general attempt statute in Title 13. But that law provides that if someone is attempting to commit a felony but is somehow interrupted and doesn't complete the act, the penalty is for the person to be punished either by the same penalty as if they had completed the offense or by not more than 10 years, whichever is less. And so because the penalty for grand larceny is a 10-year felony, and then if you use the attempt, like the fallback is a 10-year felony, the subsection B, by providing for 5 years for attempted auto theft, is actually a reduction. So they could charge that. So for an attempt, it would be 5 years instead of 10 years.
How does one prove they were attempting? I mean, somebody gets into my car and wants to go through my glove compartment. Are they attempting to steal something out of my glove compartment or to steal the car?
I think probably those are good conversations to have with your witnesses that are coming after me, but there are.
I'm saying both witnesses for the defense and the prosecution, maybe we should have that discussion here. Because I'm not sure.
I think maybe once you see the other sections, okay, which are addressing kind of what you're talking about, and then maybe once you have the witnesses, I think they can give you the different scenarios and talk about the evidence that they might use to prove or where they have trouble with.
One day I was parked on Main Street in Bennington, and I came out of the barber shop, got into my car, and the key wouldn't work. And I said, "Oh shit, what have I done?" And I kept trying to make the key work, and it wouldn't work. You know what? I was in the wrong car. Both cars were very similar. My car was, when I realized I was in the wrong car, I shut the door and went back. The fact was that they didn't lock their door. So I got in the car. Was I attempting to steal it? I had my keys in the ignition. That's what bothers me about that particular thing. I mean, I had the keys in the ignition, so I guess somebody could say I was attempting to steal it if anybody had stopped. But they were my keys.
Yeah. I think probably the next section will give you a little more context. I see Senator Hashim like smiling because I think he's pretty familiar with this issue.
I think that's my issue with this, just the personal experience of getting into the wrong car and insisting it was my car. To myself, luckily the owner never came out, nobody else noticed it. I just kind of walked away. kind of embarrassed that I was in the wrong car. But, which is another lesson about locking your car. All right, we'll go ahead and continue to walk through.
Okay. So section 2 is an amendment to the unlawful trespass statute. So subsection 1 sets forth the provision around if someone without legal authority or the consent of the person in lawful possession enters or remains on any land or in any place against where notice to trespass is given. So this could apply to a car, but the key point in this is that you have to give prior notice. And generally people are not, posting something on their vehicle that says, don't get in my car. And so there is a new provision that is added, you'll see on page 3 on subsection C, that says that a person who enters the motor vehicle of another and knows or should know that the person does not have legal authority or the consent of the person in lawful possession of the motor vehicle to do so. And then it's the same penalty that you have in subsection A, which is a 3-month misdemeanor. But it does have for a second or subsequent offense, it would be a 1-year misdemeanor. And it specifically says that no prior notice is not required. So this provision is intended to address situations where the testimony upstairs in House Judiciary was perhaps someone is in a motor vehicle, it's not their car, maybe they're interrupted, there's maybe not evidence that the person is trying to take the car itself or to steal the car. Maybe they are looking for things that are in the car, but they're not actually in possession of some of the items in the car. And so this is to address that. So you see that the language in subsection C says that they know or should know that they don't have legal authority to be in the car.
Yeah.
Section 3 on page 4, this is an amendment to operation without the consent of the owner. So subsection A, you'll see the existing language. I've just moved down to subdivision A2, which is that the person obtains, operates, uses, or continues to operate a motor vehicle of another person when the person knows that they did not have the consent of the owner to do so. And then there's a new subdivision A1 that has a lesser kind of reckless standard, which is that the person takes, obtains, operates, uses, or continues to operate the motor vehicle of someone else when the person should have known that they did not have consent of the owner to do so. So you have a knowing standard in subdivision 2 and you have a reckless standard in subdivision 1.
Back when we wrote this law, I remember clearly doing this bill on operating without the owner's consent. And what we were trying to do is distinguish between the joyride the teenager takes the car. I believe that the joyride was a 6-month misdemeanor. An actual effort to steal the car, deny the owner the property, blah, 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 was a felony or 2 years. I can't remember the penalty. So I want to make sure the committee focuses on why this needs to change. I've had no complaints from anyone about this law, the way we wrote it. I can't remember the year. I know Aluzzi was on the committee at the time, so it takes you back quite a ways.
You mean creation of the original law?
Well, back when we divided between the joyride, what we wanted to do was distinguish between those that were actually stealing a car to deny the owner the use of the car and kids who were taking the car to go out for a joyride. And had an intent to bring it back, but didn't bring it back.
And that provision is still in the law, and that is not changed here in subsection B.
Well,
so it's so I can provide you with a link to the whole law so you can see subsection B.
Yeah.
And that provides, just so you know, is that it's aggravated operation of consent without the owner if they are operating the motor vehicle, and then it has a long list of kind of different things that you would have to meet for that standard.
Senator,
I think my main, the first thing that catches my eye is the fact that for the attempt, it's a felony where you can be imprisoned for not more than 5 years or fined $2,500. But for the actual operation without the owner's consent, it looks like the penalty would be imprisonment for not more than 3 months or a fine not more than $500. And it kind of seems backwards. I would think that, I guess this is just a general comment, but I would think that if you're attempting to do something, it would be a misdemeanor with either small amounts of jail time or no jail time, but a fine. Whereas the actual successful completion of it and actually stealing the car, driving away, that would have a higher penalty than the attempt. So it seems a little backwards in the way I'm reading it.
I understand what you're saying, and I think probably it's best to listen to the witnesses. And so it was the sponsor of the bill that had asked for the attempt provision. I believe it was law enforcement that had requested the changes to 1094, and I think probably a little conversation with them about how they see these working together, or how they would envision them to be used would be helpful.
Thanks.
Sure.
Representative Burdette unable to make it today because of the death in his community of somebody that had a catch who, but unfortunately he's at a funeral. And we could probably ask him some of my questions. But any other questions for Michelle? All right, I'm gonna go then to Tim Lauder Dumont, appellate attorney with the Vermont Department of State Attorneys and Sheriffs. We may be able to inform us of why this is the way it is.
Good morning, Tim Leaders Dumont, Department of State Attorneys and Sheriffs. And yeah, I think the sponsor of the bill, Representative Burdick, can speak to some of maybe the more of the policy calls on the sentencing. Those are all policy calls. We did not opine from the department's perspective on what those should be at all. Concerning attempt, is it okay if I start with the attempt question? Yeah. The best way to think about attempt is that it's hanging on to that underlying crime, modifying it in a way, but you still need to have the jury instructions helpful. There must be the open and physical act, so yes, getting in the car, but there also has to be the intent to commit the underlying offense. So Senator Sears, you didn't have the intent to actually steal someone's vehicle, and so that would be, you weren't attempting to steal it because you thought it was your own. You thought it was
that's
your own
what I said. Would the police have believed me?
Good question.
And that I can't speak for the police on that, but threatening word, for example, if it was like not a car theft, right? Threatening words are noted to not be enough. You have to distinguish between mere preparation and the actual start of the criminal conduct. So merely planning the offense for the purposes of attempt or doing the same act, which might be innocent in itself, is not enough. You need other evidence, which is based on the facts of each circumstance. But you still have to act intentionally, and the acts must be progressed far enough to be beginning the crime. So for example, if you had the example that often has been given, and it's in case law, is firing a gun where you thought the bullet was in the chamber. Right? You were trying to kill somebody, or aiming to kill somebody, but there was no bullet in the chamber. Therefore, the act couldn't have been committed, but you had the intent. So that's just an example. As for the rest of the bill, we have had some issues that have come up. There was a big public hearing in Rutland at one point about people going in and out of cars, etc. The mayor of Rutland testified, I believe, as to some of the issues in the House Judiciary Committee. I get some of the retail theft conversation and some of this conversation melded because there's a lot of testimony upstairs. But that conversation that you just had with Legislative Counsel about knowing or should have known, it comes into the unlawful trespass piece, which is,
I think every community is suffering from a rash of people breaking into cars, looking for money, credit cards, whatever. But I'm not really questioning the need for a bill. I'm just questioning what it is that we're trying to accomplish here to prevent that. So on, my community, I did actually this morning, the Bennington Banner had a story about Manchester having a rash of people breaking into cars. Not stealing the cars, but breaking into just, looking for stuff in the cars. So, I mean, I think that's true. It's part of our problem, but how does this solve that? How does this address that problem? That's, I guess, my question.
yeah, so the issue is the notice piece and unlawful trespass, telling someone you can't come into the property or you can't come into my car, you can't come here. You may not know the person that's trying to do that. And so in the car situation, which people can park their cars on places that aren't their property, for example, but even if they are, it helps with that hurdle of, well, I didn't have a big sign on my windshield saying, please don't break into my car. I think there was conversation in one of the communities in Vermont about providing little placards that actually said that, which it would be interesting. But this helps, I think, in getting some of
Why
that
don't we
way.
just do away with the requirement that you provide notice that you can't break into my car?
I think that's what the attempt is with 3705, to do away with that in that circumstance. So I do think it's helpful.
Why would we need anything? I mean, you can't break into my house without my permission. Can you?
No.
Do I need to put a sign up saying, please don't break into my house?
And a house is a bit different.
Than a
because
car?
Because it's could be a dwelling, et cetera. And invokes other.
So if we just did away with that, it'd be simple, right?
I think that this is quite helpful, 3705, and speaking with many
Why
of
don't we just plainly do away with the requirement for notice and leave the law the way it is?
I think it's still important to have the notice requirement for unlawful trespass for individuals that, for example, getting trespassed from a place that everyone can come into, a convenience store.
Yeah, I
gas station.
understand. I'm not suggesting, I'm just suggesting that in terms of a vehicle, that you don't need to give a notice. Is that what this bill does?
That's really what this does, yes.
Okay,
Section C relates specifically to
yeah.
Can I just mention this? So if you look at the full unlawful trespass statute, so there's kind of like this broad language around lands which are open, other places that might be open, to everyone, around the notice requirement. But then it goes down and it's very specific. So there's a specific provision around a dwelling, right? So that says that if you enter a dwelling and you know that you're not invited to do so, then that's a violation. Right. So the notice.
I've seen that.
Right, so the notice is, so that it's graded depending on kind of, I think you could say, the expectation of privacy that someone would have.
Why don't we just strike the bill and put in that you don't need to provide notice that you can't break into my car?
That's what it does.
I would agree with legislation.
Well, but it does a bunch of other stuff too, right?
Well, the other sections, but I would say if you look at section 2, the amendment to unlawful trespass, subsection C, that's what it does.
Okay, but why we got this in temp language in section?
You don't have to, that's just purely a policy decision for you.
We can just do section 2. Notice against trespass shall not be required. That's lines 15 and 16 on page 3. I don't know why we're changing operation without consent of the owner. I don't have any idea what's wrong there. That's my,
Anyway, and I wasn't.
I should listen to the.
My understanding was someone from law enforcement had asked for section 3, but I don't quite understand the circumstances.
One of the issues with OOC that we've experienced pretty widespread from a charging perspective is what that does is it changes, as we talked about the other day, it changes the knowing requirements. So it's a lower threshold. It is more akin to like a reckless standard, as you were talking about the other day in a different context. So looking at the OOC section, before it said knowingly, and that is, it it's a regular standard in law, but in this circumstance, law enforcement and state's attorneys and victims have struggled with some of that because at times they have a hard time reaching that burden in these circumstances. And so that's why the policy decision upstairs was something a little bit less than the current knowing standard for the purposes of OOC. And that's why they lowered it slightly. And it is more akin to criminal recklessness type of standard. So that's what they did with OOC. The similar language at the top of the unlawful trespass standard is the similar attempt. The knows or should have known standard applies there as well, according to what H563 is trying to address. So those are the conversations that we've had.
Oh, thank you very much. Okay.
But I'd say the department is generally in support of this. I've sent it out to state's attorneys, and we've been speaking with Sarah George before crossover. She said, we need a little bit more clarity in some of these circumstances where law enforcement's called her and said, hey, there's a bit of some ambiguity here about whether the person proving the knowing as opposed to the slightly less high burden of other mens reas. And so they're just trying to address some of these issues.
So on section 3, the person should have known that the person did not have consent.
Right.
Okay. Yep.
And as to some of the sentencing questions, we didn't provide any real position on any of that. Those are policy calls for the legislature as to the sort of
I'm
balance.
not sure we need to change the sentencing practices in this law. I can understand it. I truly now understand the issue of notice against trespassing. It's rather obvious. So are there questions for Tim about anything on the bill? Tim, can you just help me understand, since we're dealing with knowing in S58 today, I'm dealing with it on the floor. We've taken that knowing standard and changed it slightly. Not everybody's in favor of it, but so we've changed it so that, as I would describe it, the careless disregard for the facts that, most drugs, heroin is laced with fentanyl, like 100%. So if you would know that if you're selling drugs.
Well, and even in an individual case, you would have to prove that
You
person.
still have to prove that person knew.
And disregard it with the new standard.
Disregarded. Right. So why aren't we using the same standard here?
Interestingly,
I'm worried about starting, assuming S58 passed and signed by the governor. I'm worried about having two different standards of knowing in the same session and wondering what the hell the legislature was thinking.
Yeah, there was a reference to S58 when they were talking about this, and likewise there was a reference that you're not far off the path in terms of that connection, because it is an important discussion about what standard you're going to use for the Title 18 drug offenses, as we've discussed in here. That standard is rooted, the one that you're aiming to change, in federal case law. So that's why I think you went with some of that language. This one, I believe Representative Lalonde can speak more to some of the policy decision, but he went with a slightly more abridged version of knew or should have known. Does it accomplish something similar? Perhaps, but the Title 18 change that you're doing in S58 is a bit more catered to the drug marketplace. This one might be a little bit more catered, even though it may accomplish something similar, to the automobile related realm of theft from automobiles, stealing of automobiles and motor vehicles. And so I think you're right that they may accomplish some similar goals, but they're in different context spaces, if that makes sense. At least that's what I've been That's what I've been really thinking about when this first came up upstairs, about that sort of, is it criminal negligence? Is it criminal recklessness? Or is it something a little bit beneath knowing? I think it's still a little bit beneath knowing because of the word choice, but that's just, there was quite a bit of testimony upstairs about it. And I think they tried catering it to this context, and you tried catering S58 to that drug marketplace context and the federal case law.
Okay. Thank you. Any other questions for Tim? Thank you.
Thank you.
Rebecca?
See you a little bit later.
Defender General. Well, we got a lively discussion
Nice.
about stealing cars.
If I might, I did talk with Senator Norris
Yeah.
last night. He's fine. He said he feels better than he has in years. He's gonna maybe be on Zoom Friday, but he says he'll be back in person Tuesday.
Well, I got a message from Ashley that he'd be on Zoom tomorrow and Friday.
Oh, okay. He told me Friday, but
Well, that's great news that he's feeling better than he has in
Yeah.
years.
he said they put in stents without any anesthesia. I don't know how they.
I don't know how they did that.
I guess
Maybe-
Local anesthetic, they
Maybe
go
the
through a
right-
vein in the leg and they thread it up through.
Wow.
And
Yeah.
so they just need a local where they make a
Well, when
little
they-
incision.
When they did that exam with me, they put a thing in through my wrist. They just did some local
Mhm.
to put the thing in, and then you could see all my veins and my heart, the whole 9 yards. Of course, there was a conveyor line at the Albany Medical Center. There was like 8 beds, and they had people in all 8 beds, me and 7 other people, and they had 3 nurses with each person, and they were doing, it was just like a conveyor line. And then the doctor would come to each one of the 8, and, spend 5 minutes with you.
Crazy.
It is. It's more than medicine and Henry Ford.
That's amazing. Okay.
That's not part of H 563. So we have Rebecca Turner with us from the Defender General's office.
Good morning, everyone.
morning.
Rebecca Turner from Defender General's Office. 563 auto trespass. I testified in House Judiciary on this. I'll share my concerns. But in terms of the personal experience sharing and whether or not misidentifying a car and whether that's attempt, I agree with Attorney Ludus-Dumont that attempt requires the underlying intent of the felony. So grand larceny requires a mens rea of an intent to permanently deprive and take away an owner of their property. And so because that intent wasn't there at the time, there wasn't an attempt for grand larceny. Attempt requires, in our Vermont case law, it's been teased out, the commencement of the consummation of the underlying offense. You've had to start to complete the offense. You haven't completed it, so it's pretty far along. So let me jump into what I think is the most concerning part before I talk about the sentencing amendments discussed here. In fact, the changes to the attempt punishment for grand larceny actually lowers the current punishment for attempt. Attempt is defined generally in Title 13, Section 7, unless individual offenses specify a different punishment, right? And so for felonies, it's 10 years or whatever is punishable for the underlying offense. So if grand larceny is right now punishable for 10 years, so right now it's 10 years. So in terms of not completing it, it's something we would support the change there in Section 1. But I really want to focus on Section 2 and Section 3 and talk about what has been a concern this morning, which is tinkering with the mens rea. Now, I want to bring us to page 3 in Section 2, and this is the additional language, the unlawful trespass statute, this very old statute, which codified both common law, unlawful criminal, unlawful trespass. So know that this statute and the case law that is developed in our state Supreme Court sort of has brought in this wealth, this deep history of this offense. Again, with roots in common law, English common law, and we draw upon what the other 49 states have done on this common law criminal offense and lawful trespass. I'll put this right up front. I could not find a legislature or another state that has dropped the mens rea to a should have known. A should have known, which is what's happens in line 10 and 11 here, should know. So now you've eliminated a mens rea requirement. There is no longer a requirement that the person knows or recklessly knows or even has criminal negligence, right? You just eliminated it. It's now turning into just objective standard, a reasonable person should have known. They did not have authority to enter the car. So Senator Sears, I think that your personal experience you shared about mistaking another vehicle as your own, going and putting your keys in.
Yeah.
Let's say you get in and open up the car. Under this proposed language, that would be a crime. It'd be a completed crime because it's merely entry into a vehicle where you should have known, not what was actually meant. I actually thought this was my car. I'll share that I don't think that is. I think you have company there, and I'm speaking from personal experience. I've had something similar. Newly employed with the Defender General's Office, 2007. The state vehicles back then were not the Priuses they are now. The electric vehicles, they were the Honda Civic Tans, and it was a similar experience of having my keys to take my state vehicle to court and clicking and hearing the beep. So I entered the car, and the keys wouldn't work, my keys that I had. But I looked down and there's keys in the car, console. Someone left the car open and had keys in the car. And so it was a mistake, my mistake, because I thought I was in a car that I had authority to drive. I had signed it out, taken it. And so I think that under this, it doesn't matter what was my intent. I had no intention to take away that car, permanently or temporarily. That's a separate offense here, right? And I wanted to share with you police log out of the Valley News, March 4th. This was Saturday, March 2nd. It was reported at 8:48 a.m. Police were called to the Montverde Cafe to investigate an apparent automobile theft. The victim had left his 2024 Subaru Outback running outside with the keys still in it, went into the cafe, and when he came out, the car was gone. Just as Woodstock Sergeant Chris O'Keefe arrived to begin his investigation, the vehicle was returned by an older gentleman who said he had taken the car by mistake. O'Keefe said that the gentleman drove the same type of car with the same make, model, and color and had mistaken the Subaru for his own. It was only after he started driving and looking around the interior that he realized it wasn't his car and returned it.
Thank you. I take the point, and reading through this quickly for the first time, it does strike me as a little heavy-handed. I'm just wondering, though, in the hypothetical that you're talking about, should have known, wouldn't the case with you and the older gentleman, they drive the exact same make and model of car, wouldn't a prosecutor say, okay, well, that's a reason why maybe should have known doesn't apply to them, because there are clearly circumstances that, but if somebody entered a car that was nothing like their own and didn't bring it back, but was apprehended with the vehicle,
Yeah.
I think that's more what that seems likelier that would be prosecuted rather than the cases you're talking about.
And I think then you get into a question of prosecutorial discretion.
Yeah.
And that's what this statute doesn't check. It just gives that green light for disability. If there is a prosecutor who does decide to charge this, now this is the burden. And the burden.
So, since we had similar experiences of getting in the wrong car, what if we struck or should know on line 10 and the start of line 11, just struck or should know?
I would support that. That would get to eliminating that issue and bring this and keep this statute consistent with where the other states are on unlawful trespass. They require a knowing requirement, a subjective state of knowing you're entering property without authority, because they want to exclude the inadvertent trespass.
I can just see the headline now, Sears, arrested for attempting to steal a motor vehicle. I was telling a story about it. I got out of my car, got a haircut, came back and got into a car that was very similar. And I was very frustrated because I couldn't get the keys to work, and I thought I had my wife's keys, and we both have Fords. And I'm trying to get the darn thing, and luckily I didn't break the key in the ignition. And finally I looked around, and yes, it wasn't my car. So I, snuck out of that car. Hopefully nobody saw me, and got into my own car and drove off. But what if I got arrested? I should know. That was my concern. But I think about the headline, legislator arrested for drunk driving at the State House at 8:30 a.m. And then when you find out what the BAC was, it was .081, which can be anywhere from .06 something to a lot higher. So, but you have the headline. I certainly wouldn't want a headline saying Sears arrested for trying to break into a car, which was not my intent. But if I have the should, I think we could take the should know out.
I would support that.
So I missed the walkthrough, but is the purpose behind the bill to prevent people from stealing cars or from getting into cars and occupying?
There's two things that it does. One is that changes the knowing standard. The second is, I didn't realize this, you have to give notice against trespass in Vermont, unless it's your home, which is accepted. But evidently, unless you put a sign on your car saying, please do not break into my car, you do not have permission to break into my car. I guess they can. I may be oversimplifying that, Michelle, but
the section on the unlawful trespass is to address, let's say if someone is, your porch lights go on, you walk out, somebody's in your vehicle. They are probably not trying to steal it. They haven't removed anything from it yet, but they're rifling through your car, right? And it's right now unlawful trespass, subsection A, could be interpreted to include by the definition of place. It could be a vehicle. However, for that subsection A to apply, you have to give prior notice. And so this provision is to say, generally, cars, if it's not yours, you're not supposed to be in them. Then section 3 is to address unlawful operation of a motor vehicle without the owner's consent. And there is a knowing standard there that you don't have consent to use the vehicle. And there is a new, it keeps that, but then it has a lesser mens rea of if you knew or you should have known that you didn't have consent. And that was, that's a separate from the unlawful trespass issue. This was something that was requested by law enforcement around certain circumstances of them having difficulty proving that the person, was arguing, well, I didn't know I couldn't take this car. And then the first section is on attempts. And is kind of its own thing there.
Sorry, Senator.
And it lessens the penalty for grand larceny, for attempted grand larceny if you're stealing a vehicle. But there is some dissonance between the penalties of operation without the owner's consent and the attempted auto theft in section 1.
Senator Rashim had a question, and then Senator Miles.
Yeah, it was more so in response to what you were asking. I think at least from what I've heard from many constituents, is that their concern is the ability for people to go through their cars and when they come out and confront the person who's in their car going through their stuff, they haven't taken anything yet, nothing can happen. So even if the police show up while the person is in that car. There's no underlying crime, so there's no way to develop reasonable suspicion to do any investigation, and that's the general concern. I haven't really heard anything about people having their cars stolen, so I'm not sure how that got attached to this, but
Yeah, okay.
Since the house game, we'll get back to the witness.
Yeah, I guess my question, and it maybe for Rebecca, maybe for Michelle, is sort of the inverse of, and so we're changing some of these standards, that like, if it's not your car, you assumedly can't get in it. But if I tell someone they can, are they, like, what I think about is I sometimes will drive myself to the airport and then tell my brother to go get my car so I don't have to pay for 10 days of airport fees. If he is getting in that car and for some reason someone says, oh, he's stealing that car, is he then held to this even though I have given him permission?
Again, if your brother knew that you gave him legal authority to drive, that's no longer relevant under the proposed language. It's just a should have known.
Right.
Should have, right? Should have known. And so that would be the counter.
Mhm.
But again, right now, the subjective knowledge is the requirement, right? And so that's the risk. I think, so that's the problem. I would certainly, so it would go a long way to eliminating the should have known language, bringing it back to in line with not only the rest of the unlawful trespass statute, which requires that, but it brings it in line with the rest of the country. Yeah, I could not find any other state that had brought it down to this. And it's not just lessening the mens rea, because this is the same mens rea that is proposed in the other operation without consent of voter. It's not a lesser. When I think of a lesser to knowing mens rea, I think of recklessness, which is lesser than knowing. And then lesser than recklessness is criminal negligence. This is eliminating a subjective mens rea entirely, right? It's turning to an objective, reasonable person standard, should have known, right? It's not even a gross departure of the standard of it's just plain old negligence, right? That's a civil standard. We don't see that in criminal law. We certainly don't see it in the unlawful trespass. It would be brand new in this other statute operating the. So I would recommend, and we would seek to have that language removed there as well. And,
What about if you said, a person who enters the motor vehicle of another and does not have legal authority or the consent?
say that
So
first
in other
part.
words, you get rid of knows, or should have known altogether. A person who enters the motor vehicle or of another and does not have legal authority or consent.
Again, it doesn't exclude the inadvertent trespasser, right? They may in fact not have legal consent, like Senator Sears, like
I've done it too.
this person who reported being mistaken and driving off, right? You don't technically have it. You don't.
just quickly, I think that if I'm remembering correctly, if you don't have listed what the mens rea is, the default for a state would be recklessness. That's my understanding. I don't know if that's, unless it's listed somewhere else in the chapter. Is that?
It is a little more complicated. It's actually sometimes we'll default it to knowingly, but where you look at the rest of the section and the statute and what the legislature has used it in some parts and not in others, it is more ambiguous.
I don't know. I think if we just strike knows or should know, excuse me, or should know, you accomplish what you're trying to accomplish.
The other issue I want to clarify is how the notice issue, and what I'm hearing is the reason for this. Just to be clear, the current unlawful trespass language statute in A1 includes, as the Vermont Supreme Court, not just land, doesn't just include buildings, it includes, as they said in State v. Stokes in 2013, planes, trains, and automobiles. So whether or not that first part includes automobiles, it clearly does. If the concern is, and the other part does require a specific type of notice, you have to provide actual communication. actual communication that you're not allowed to be on that land. So that's the no trespass signs that you see. That's the specific standard for notice, actual communication. What's proposed here in lines 15 and 16 is just a general notice of against trespass is not required. I think that is too broad. Now you're slipping into the knowing and inadvertent trespasser. I think that if you say actual communication is not required here in this instance, then that eliminates the need to put in signs, I suppose, in the cars that you see on land, no trespassing here, right? Again, it's mirroring the language in the statute, which requires actual communication. It spells out the specific notice, right? The language is you person may not enter or remain on any land to which notice against trespass is given by, and it spells out actual communication. My understanding of what law enforcement's concerned with is that piece of actual communication.
Well, we haven't heard from law enforcement yet, so.
And so, yeah, so in terms of the issue of notice, if you eliminate the need to prove notice, I think you undercut the mens rea requirement of knowing, right? So it blurs together very, very closely. And so you can get at the concerns here by addressing that, is it the actual communication signage issue? We can address it. The other concern in that subsection, it's buried in between, sandwiched in between. It's a second subsequent enhancement penalty for an offense that currently has no mens rea, right? So while the rest of the unlawful trespass conduct is 3 months, if you have a second or subsequent, and now is maximum imprisonment of 1 year. Again, those kind of aggravating sentences to imprisonment based on the same underlying culpability, and here, no culpability, right? No mens rea here. What does that further? Again, you're encouraging more incarceration. Do the studies support that actually will deter the conduct? And this committee has heard in other bills that increasing penalties by way of incarceration actually doesn't deter. It doesn't actually increase public safety. Does it incapacitate? Yes, I think that's clearly what, yeah.
So for a future meeting, we should hear from someone from local law enforcement, perhaps either the chief or mayor of Rutland or the chief of another community, pick a community. And we should hear from Jennifer Coleman, the Center for Crime Victim Services, and we should hear from the Department of Public Safety, whether it be Matt Birmingham or somebody he wants to send, or
and I reached out to Jen Coleman last week.
Yeah.
She said that her testimony would be quite brief, and she was actually going to submit some written testimony that should be receiving it later today.
yeah, and maybe there's some victims that somebody can suggest to.
Again, the point is if this is about addressing that, we already have a statute. We already have petty larceny. We already have guardian.
Right.
We already have attempt.
Yeah, I'm not convinced that there's a need to change the law regarding stealing of vehicles. I thought that what we did years ago was pretty sufficient, and I hadn't heard any complaints about that section. So I'm inclined to not deal with that, but more deal with the rifling of vehicles and people coming in. You know, that's what's been rashes in certain communities and then goes away and then comes back.
Again, I would just caution, if you start tinkering with prohibiting or limiting the notice, you are really bleeding into the mens rea, because that is how traditionally, historically, we've proven that someone is knowingly, without knowing that they're entering property they don't have legal authority to do, because they are on notice somehow that they shouldn't be there.
I'm sorry.
This might be
Yeah.
a silly question, but I mean, so when you compare it to somebody entering a house, I mean, obviously, you know, they don't get notice that they can't enter somebody else's house, but I believe the standard is still knowingly. So can you explain the difference for me there and for the rest of the committee?
Well, you mean
Why isn't it bleeding into the mens rea with?
of knowing of the section? What was the section that you were referencing in the lawful trespass in the dwelling? I don't have that
For
handy.
dwelling?
Yeah, I mean, that is possibly the separate one we're
Yeah, I don't
talking
think
about.
I don't think it's required.
But
And so, I mean, that was my question, is that if you were saying that you could get rid of actual communication, but are you saying that like you're proposing that with regard to the vehicle, that you would still require a notice for like having a sign on your car that somebody's not supposed to come into your car? Or how would that person still receive notice that you're not supposed to be in my car?
The doors are locked. The car is not in your driveway. You don't otherwise have, you're not thinking that you are expecting to have authority in to access the car in the public parking lot, right? The permission that you got gave you notice that you had authority to drive the car, right? That is the part of the notice. If there is no requirement here, again, looking at the way this language is used here in 15 and 16, just see how it can be so broadly interpreted. Notice against trespass shall not be required against this subsection. Notice is broader than actual communication is my point here. So if the concern is trying to not criminalize the inadvertent trespasser, right? You don't want to capture the innocent person who's making a mistake. And then you're not requiring notice to be shown. There's tension there when you start leaving the actual communication. This is what I'm trying to point out. The private home residence, right, it's different. The vehicle is what you're talking about, why people can mistakenly enter a car where we have so many of the same makes and models in Vermont, right? You don't make that same type of inadvertent mistake into someone's house, right?
I mean, it can happen.
All right,
I think
it
someone died because it happened in
I mean,
another state.
You're right. And so,
I was just gonna
Actually,
say, so with the
apartment
dwelling,
buildings are
Exactly.
sometimes confusing.
with a dwelling
Yes,
house, it
that's-
says, a person who enters a dwelling house, whether or not a person is actually present, knowing that he or she is not licensed or privileged to do so, is a 3-year felony. So I don't understand why.
So it's a
an
special
issue. So
treatment.
you don't have to have some kind of actual notice, you don't have to have a sign, you don't have to communicate notice why they can't do the same thing with
I
a
think
car.
that the car should be exactly the same as the house. I don't see any reason it shouldn't.
my suggestion is because that A1, I'm just capturing the language in A1, that actual communication notice, that it may, for clarity's sake, use that in reference to the notice that you're bringing into this new subsection. Because know that in the case law and the way that notice is understood, it is broad. It can be broad, right? And so A1 is using a specific type of notice. And so if that's the one that it's on par with in terms of the penalty, the 3 months, this is not comparable to the greater penalty of that unlawful trespass of the dwelling. I think you said it was 3 years, Michelle. I would encourage you to just sort of analyze that notice language in the context of the notice language used in A1.
Any other questions? Thank you very much. Judge Zone, are you with us?
Yes,
Oh, great. How are you doing?
I'm good, thank you. Thank you.
Oh, good. I've had my knees shot up too.
Well, it was,
The doctor says it's an oil change every 6 months.
I've gotten into that routine now, so trying to be like with my car, getting the oil changes done when I should. Hopefully we keep.
Well, you have to take it easy the day of the injection.
That's what I'm told.
Yeah, I'm well experienced with that.
I hope my result is like yours.
Well, back to H563. Thank you for joining us.
My pleasure. So Tom Zone, Chief Superior Judge. With respect to H563, it is in many ways a policy bill in terms of the positions that are being advanced, for instance, under grand larceny, where There's a change as to the attempt penalty, maximum punishments, and adding in the other language. And I came in the tail end of Ms. Turner's testimony relating to the issue of entering a motor vehicle. And I recall that when I spoke in the House on this bill, that one of my concerns that I expressed was what she touched on, and that was that inadvertent, you're in the parking lot and you get in the wrong car. And yeah, you should know not to get in that car, but sometimes it might be the same color parked generally where yours is parked, and you open the door, and it's not until you look in and see that there's a Coke there and you don't drink Coke that you go, oops, and you quick shut the door as you're starting to sit. So I just point that out because I think that is not entirely clear here whether that is actually a defense, because it would be a very fact-driven situation. So that's a policy, how the legislature wants to handle that type of circumstance. In terms of the remainder, again, as far as operation without owner's consent, the addition of the language for a person should know or should have known that they don't have consent, that adds a mens rea intent requirement that is not currently there, and that's a policy decision. And irrespective of what, how the legislature comes down on this, the court would instruct the jurors and develop the elements for use in the cases as is set forth in the statute.
Thank you. Senator Hashim.
Hi, Judge. Thank you for your testimony. My question, basically, would we be able to avoid sweeping up the inadvertent instances where people are, accidentally entering cars if we just get rid of the should know, if we get rid of that language and just say motor vehicle of another and knows that the person does not have legal authority? Does that fix things?
I would seem to address that type of concern, because the element the state would have to establish beyond a reasonable doubt is that when you open that door, you knew absolutely that you did not have the authority to get in. And you had the intent, you had the knowledge that you should not go in that vehicle. It wasn't your vehicle. As opposed to, you should have known because it's, you have a Honda and this is a Toyota, they might be the same color. In other words, it gets rid of that issue of should you have known, what I'll call the recklessness type component, as opposed to the actual knowledge. But again, that's a policy decision.
Thank you. Yeah, I think we should get rid of should know.
Mm-hmm.
Well, I think we're pretty well, if I would hazard a guess that, Michelle, if you were to redraft C to take out should know, and I don't know I don't know if the penalty, if we could still discuss the penalty, whether it should be higher or lower or whatever, but what is the current penalty?
The first offense, if you went under subsection A, is the same as what you have for C. The thing that's different is the enhanced penalty for the second or subsequent offense.
Okay. Anything else on this bill, Judge?
No, nothing further. Thank you.
Oh, thank you very much. We'll see you soon. See you tomorrow.
Yes, we will. Have a good day, everyone. Thank
I
you.
just wanted to ask,
Senator Booth has a question.
not for Judge Zone.
Oh.
Thank you, Judge.
All right, take care.
For Michelle, if I could. And it's just a style question. So I read that sentence on 10.
What page are you on?
I'm sorry, page 3,
Uh-huh.
line 10 through 13. So it seems to me that it must be the style manual is making so that you don't use a pronoun. So it's a person who enters the motor vehicle of another and knows or should know that the person. To me, that the person is ambiguous because you've referenced two people in the previous set of words. So it seems to me that instead of saying the person there, if you said they, it would be easier to understand. But are you required to just keep using the person?
It is stylistically what we do from a drafting standpoint as we've gone to gender neutral language.
Yeah.
And there is always a yearly hot debate amongst the lawyers and the editors around when we can use they, should we ever use they, those particular circumstances, and should we say the person? So I can add an additional modifier to the person. To me, it reads fine, but I respect the fact that you're saying that you stumble over it a little bit. I can look at it to see if there's another way to say it without making it too clunky or cumbersome, but that is the way that we do it, is we just refer back so that
Yeah.
we're avoiding pronouns.
Yeah, because, there's clarity on the motor vehicle of another becomes the person in lawful possession of the motor vehicle, but the person who enters the motor vehicle, doesn't get qualified, as you say, in the next one.
But if you look at the rest of the sentence, says that the person does not have legal, knows that the person doesn't have legal authority or the consent of the person in lawful possession.
Right, so I
So
guess,
if you were gonna try to interpret that,
I guess what I'm saying is on line 11, it's possible that you would, it doesn't turn out to be the case when you read the whole sentence, but a person who enters the motor vehicle of another and knows or should know that the person does not have legal authority, that could be talking about.
yeah, but it's or, you have the conjunction, you have to read the whole thing.
Yeah. And as I say, by the time you reach the end of the sentence, I think you can get a sense of it. But I was wondering if it was possible to use pronouns to.
I'd have to schedule a meeting with my editors and argue the
Okay.
point.
If it is,
It's not, we don't use
if it's
they.
even that much trouble, don't worry
Yeah,
about it.
it's not, it would be a deviation from
Okay.
how we draft the
Then
statutes.
let's not deviate.
If I could sum up where the committee's at, you and Michelle are gonna have
We
a
can argue over
discussion with the
over
drafting
pronouns
editors
later.
about proper English, and
Yeah.
you being an English professor, I think that's entirely appropriate, and we'll follow whatever the two of you come up with.
I will follow what Michelle comes up.
But the committee, I would say the committee needs to be convinced of the need for sections 1 and 3 dealing with the operation of a motor vehicle without the owner's consent. And the committee would like to get more clarity on the notice against trespass, but is definitely in favor of striking the word or should know
Yes.
on what page 10 and 11. I mean, lines 10 and 11 of page 3. And I have one other question, Michelle, I don't know anywhere else we say attempting to steal. It's always attempting to operate the vehicle without the owner's consent, and that's kind of
Right,
clunky.
it is,
I mean,
at the
to be
risk of like
consistent,
entering a little personal opinion here, I mean, I think the kind of shoehorning auto theft into grand larceny when you have, the 1094, you know, I mean, I don't know that you need that, or I don't know what value there actually is to
section.
that.
Mhm.
So I'm happy to say it any way that anybody wants it, you know, but I don't think that section has gotten a lot of discussion other than around the policy of reducing it, but I would be interested in hearing from Tim about whether or not, you know, if you had an attempted auto theft, I mean, wouldn't people be using 23 VSA 1094 instead of grand larceny anyway, or do those types of things get charged sometimes as grand larceny? I don't know,
But it's always been the two standards. One is attempting, I would think that you still is an attempt to steal the vehicle. I don't know why that's any different. I mean, why that's not part of the law, or we could just say or attempts in the statute regarding, operation without the owner's consent. You could just say or attempt. And the same with, and you have the two standard, I mean, we developed the two standards, and we didn't call it grand theft auto, but, you know, there was I can remember joking around this table back when we did that, was, should we call it grand theft auto, because there was a game at the time out, Grand Theft Auto. And, you know, there was some But no, we decided to keep it as operation without the owner's consent. So we distinguish between the joyride and the other. So I'm not sure what this needs to change, but I think you should, if we're gonna add attempts, we should do it within those two sections of the law. So attempts to operate without the owner's consent, rather than starting this grand larceny thing, which is I see as very clunky.
So can I just add, just to bring a little context, so if you, the joyride that you talked about is
Yep.
a 2-year is like up to a 2-year misdemeanor.
Yeah, I know.
You know, stealing the car, is the aggravated, and that's a 5-year felony. So
Right.
under an attempt there, it's gonna be,
Yeah.
it's gonna be half the felony, it's gonna either be what's provided, which is gonna be 5 anyway.
Or what was the intent?
So there's no policy, I don't know that there's any advantage to having one, do you know what I'm saying? Because you get that
Right.
in your,
So if
in
we're gonna do attempts,
the other one
if we
anyway.
need attempts, I would do it within the current.
Right, but I don't think you need to add attempts because you have the default that's already in Title 13 in
right.
Section 7.
Yeah, I'm just saying if we needed attempts. I don't like this section of grand larceny. I think it's confusing, actually. But I remember one of the interesting one was that came up during our discussion on the auto theft was the woman stole the car from her boyfriend, took it to North Adams, Mass, and sold it to a salvage yard for $25. Now, it was worth a lot more than $25, but she got back at the guy. And, you know, it was clearly operating without the owner's consent, but also sold the vehicle. So that was one of the things that came out during that, and that was interesting.
Clearly, she should have known.
Clearly, she knew it was her boyfriend's vehicle. But she got back at him because it was crushed and gone by the time he got out. So anyway, we'll come back to this next week. Tim?
I might suggest a Chittenden County Law Enforcement Department as well, as I know they've been dealing with this issue quite a bit. So if you were going to bring in law enforcement, I believe I've heard from Chief Burke as well.
Yeah, I don't think the committee, I think that the committee is understanding the notice and the rifling in the cars, which is Section 3 or 2. It's whether the need for Section 1, I think we don't believe it's needed, and if why would we make changes to Section 3 to the operating without the owner's consent? If attempts is already in there. So, yeah, but we can hear from somebody. I know the House heard from the chief in Burlington, but I'm wondering Senator Bahowski would rather some other chief or Senator Baruch would let.
Fine,
Name
however,
a chief.
well, I mean, the Burlington chief probably has as much experience with this as anybody.
Yeah.
Because I know that front porch forums for the last year or two have been full of people talking about their cars being rifled.
Yeah, no, it's a I mean, it is a problem, and I'm not denying that. I just don't know that this is a solution.
I'm certainly happy to hear from Chief Murad or, you know, Chief Hogue in Essex,
See who
but
we
I,
can get from either chief, do you have contact with them, Tim?
The chiefs of police president is actually Senator Bihofsky's chief of police, Chief Ho, so he might be able to coordinate who from
Okay,
Chittenden.
so who should do you want to contact the chiefs?
I'd be happy to send a note to Chief
Would you
Ho,
on
who's
behalf
Senator
of Ben and
Yeah.
Please CC me.
Senator Baruch and Senator Bowski? Do you have anybody, we added Mark Anderson.
Yeah, the Brattleboro Chief of Police or the Assistant Chief would probably be interested.
Okay,
And would you like me to reach out to the Rutland Chief?
pardon me?
Would you like me to still reach out to the Rutland Chief of Police and that?
No, I think we'll just Brattleboro and Chittenden.
Sounds good.
We've heard from the Bennington Police a number of times. I don't think we need to hear from them on this.
I also wonder, because I know this is kind of a larger Chittenden County, I mean, I don't think it's only in Chittenden County, but I know that Chittenden County has been struggling with this, if it makes sense to hear from Sarah George, given that she's got a purview over all of Chittenden County.
Well, we should hear from a state's attorney herself, but maybe another defendant's attorney. If you have one that works in the field, I mean, I guess you call it the field.
I can reach out to Sarah and see if she's interested.
Yeah, if Sarah's not interested, I'm sure there's another one, but you could reach out, and then if you could reach out, maybe Fred Bragdon by Zoom would be good. I mean, he's been public defender for 100 years.
Yeah, there's a number of them, of
But if you can reach out to one public defender, I'd like to hear from who's, you know, on this bill. And so again, the issue is, the needs for sections, I'm not sure there's any need for section 1, but the need for section 3, and does section 2 actually solve the problem? And maybe we could take up that retail theft bill at the same time, Ben, so that they could testify on that one too.
Good idea.
So we can, I mean, rather than having them come back the second time and the same, blah, blah, blah.
This is for the chiefs.
Yeah, I'm talking about the chiefs
And
and
Sarah George.
Sarah George or whomever, and,
I'll reach out to Tracy Shriver as well, perhaps,
yeah.
for Winnie County.
If you wanna reach out to Fred or some other longtime public defender.
I will.
Fred may be busy with the flower shop right now.
He is busy. We'll figure, we'll find some.